afternoon. Today we offer you the monthly review of current changes in legislation. In this broadcast we present the main regulatory enactments important for Russian business. A new form of tax declaration on estimated income for NDFL has been put into effect. This declaration is to be presented to taxation authorities by individual entrepreneurs and persons engaged in private practice. The new form of declaration is adapted to the aims of using electronic document flow. The requirements on filling the declaration in a paper format as well as in an electronic format using software are defined. On the basis of the declaration, the advance payment is calculated according to the personal income tax for the current tax period. The Ministry of Finance has defined the procedure according to which the banks can repurchase preference shares from the Russian Federation, which were placed during the financial crisis. The law has established the right of the shareholders, owners of ordinary shares, to purchase such preference shares from the Russian Federation during a specified period, as well as to transfer this right to a bank. This period is from the 1st of January 2014 to the 31st of December 2015. The order of the Ministry of Finance has defined the procedure according to which a shareholder of the bank can transfer the right of share acquisition, including the procedure of repurchase, pricing and contract conclusion of share acquisition. More specifically, the list of the documents enclosed to the bank offer to repurchase shares and the time period for its consideration by the Ministry of Finance, as well as the reasons for rejection of the bank offer, are stated in this order. The court practice regarding application of the pledge legislation has been regulated. More specifically, the issues of the out-of-court levy of execution on the subject of a pledge have been considered. It has been stated that courts should bear in mind that the agreement between a pledger and a pledge holder on the out-of-court levy of execution on property can be considered as a void deal under the Article 168 of the Civil Code of the Russian Federation. The following case has been discussed. A pledge holder under the contract levied execution on the subject of the pledge, and the property was alienated to the third party. In this case, the courts should rely upon the following statement. A pledger has the right to retrieve his property from the purchaser. This situation doesn't exclude the responsibility of the pledge holder to compensate additional expenses and other losses. The Supreme Commercial Court of the Russian Federation has considered the question of violation made by state or municipal customers before applications for participation in the auction are examined. The violations can be appealed to the Federal Anti-Monopoly Service of the Russian Federation by any person. Any person can appeal the statements of the auction documentations, the information about the order to be placed, the procedure of directing clarifications of the statements to participants, and the procedure of documentation submission. Specifications and supplements have been inserted into the legislation on territorial planning. From the 1st of September 2011, new forms of the Urban Planning Code of the Russian Federation will come into effect. According to them, federal, regional and local authorities will be obliged to provide access to draft documents of the territorial planning in the special information system in the Internet. The procedure for conducting public hearings on the project of general layouts of human settlements has been significantly amended. Legal entities and natural persons have the right for preparation of the documents on territorial planning at their own expense, including the planning which involves placements of objects of federal, regional and local significance. Also, the meaning of territorial planning has been specified. This review is prepared by the lawyers of Tensor Consulting Group. We hope it will be useful for you and for your business.